Gormagat Ceann Comhairle. I want to thank the Minister for bringing forward this piece of legislation today. We all know the reason that we are here is because of the recent decision of the Supreme Court in the Zalewski case. It was probably one of the most important decisions given by the Supreme Court this century. It has resulted in this legislation coming before the House today. I think it's important just to remind other people who may not be here, because I'm conscious that all my colleagues here would know the facts of the Zalewski case, that we just recall what happened in that particular claim. Mr. Zalewski claimed that he was unfairly dismissed. He was entitled to bring a claim against his employer under the Unfair Dismissals Act 1977. Under the procedure and the architecture that we have put in place, he does so pursuant to the Workplace Relations Act of 2015, and his claim was heard by an adjudication officer at the Workplace Relations Commission. He did not get a fair hearing. In fact, he didn't really get any hearing. And rather than listening to my description of it, I'd urge colleagues to reflect again on what Mr. Justice McMenamin in the Supreme Court said about the hearing that Mr. Zalewski got, in which he described it as being Kafkaesque. But in any event, his claim was rejected by the WRC, and as a result of that, Mr. Zalewski decided that he would challenge the constitutionality of the Workplace Relations Commission and the fact that it had operation over such a wide, broad range of legislation, such as the Redundancy Acts, such as the Unfair Dismissals Act, such as the Employment Equality Act. His contention was that the Workplace Relations Commission was administering justice. The Workplace Relations Commission said it wasn't administering justice. I think that's something that we probably all should reflect on here, because, I'm conscious if a person is sacked from their job and they bring a claim against their employer, it's probably one of the most significant steps that they will take in their life. Nobody likely takes a claim against their employer or indeed anyone else. However, there are circumstances where employees, where workers are entitled to bring claims against their employers. And I've listened very carefully to what Deputy O'Reilly said and Deputy O'Riordan said, and it appears to be the case that there can be a criticism made of an employee if they bring a claim against their employer. I think it was referred to that this can have sort of a chilling effect on an employee. That may be correct, and I know my friends weren't in any way criticising employees who take such an action. But I think it's important to emphasise that in our system, people are entitled to bring claims, and it shouldn't be stated or it shouldn't be thought that because an employee is taking a claim against their employer, that in some way that employee should be criticised. But in any event, Mr. Zalewski went to the High Court, and the High Court looked at it. It looked at what's happening up in the Workplace Relations Commission. And the High Court applied the tests that were established in MacDonald against Bord na Gán back in the 1960s. It set out 5 tests for the administration of justice. The High Court stated that this wasn't the administration of justice. The reason it said it wasn't the administration of justice is because the Workplace Relations Commission doesn't have the power to enforce its own orders or judgments. Instead, what happens is that the Workplace Relations Commission, if you're trying to enforce a decision of it, you have to go to the District Court. Mr. Zalewski then lost that case because the determination of the High Court was that it was not the administration of justice. He appealed to the Supreme Court. The Supreme Court said it was the administration of justice. And that's a very significant development, because throughout the High Court case, throughout the Supreme Court case, and from 2015 onwards, the WRC has been stating that they're not administering justice. So we now know that they are administering justice. And ultimately, there was a split decision of the Supreme Court. I think it was 4-3 in favour of a finding that it wasn't unconstitutional, but there were certain aspects, as have been identified by speakers here, which were regarded as requiring change. It's a big question to determine, well, whether or not a body is administering justice or not. Under our Constitution, Article 34 says that justice shall be administered by our courts in public, save in certain circumstances. And then the article sets out the courts that we have in this country for the administration of justice. However, we also recognise in this House that justice can be administered elsewhere if that is for the purpose of limited or local jurisdiction. And that's why Article 37 of the Constitution is very important, because it provides that limited functions can be carried out by statutory bodies other than the courts, I suppose, which are established under the Constitution. We've seen a trend in that, not just in recent years, but I suppose in the past 100 years, that legislation will be enacted by a parliament in any country, but that it will allocate responsibility for the determination of disputes under that legislation to a new statutory body. There are many of them in Ireland. We have the Workplace Relations Commission, we have the Residential Tenancies Board, we have other boards and functions that fulfil determinations of disputes. They are administering justice, but they are doing it on a limited basis. The Supreme Court in the Zalewski case said that in fact what's happening here is the administration of justice, but it's been done on a limited basis since it relates to workplace disputes and since it has some limitation in terms of the financial award, although there are extensive powers available to the Workplace Relations Commission when it comes to the determination of issues and the making of awards. I suppose behind all of this, there's a certain amount of concern that the Oireachtas has that if we do not take issues concerning the administration of justice away from the courts, that it will result in lawyers and it will result in inefficiencies. And the objective, and I suppose the purpose behind establishing the Workplace Relations Commission as the place where employment disputes will be resolved, is the well-intentioned objective of trying to make the system more efficient and trying to make the system cheaper and to ensure that it doesn't get bogged down with lawyers. All I would say in conclusion in respect to that, it is absolutely vital that anyone who brings a claim that is involved in the administration of justice and that is seeking justice, that they get fair procedures, that they get a fair hearing. And I believe that this legislation will go a considerable way towards that, but we have to ensure that all claims before the Workplace Relations Commission are heard in a very fair and just way. Thanks very much, Ken Dorna.